Hi, I wanted to welcome you to the Divorce Planning Podcast. I'm Carri Goldring, and I'm in the mortgage business, and I do planning pre-divorce for people who are either going to refinance their home, do an equity buyout, or plan to purchase a new home and make sure that everything in the divorce decree is worded properly and the numbers in the planning is taken care of so that you can go through the underwriting process smoothly. And I would like to introduce you to other people who are interested in the divorce planning process so you can get a real education of what's involved. Hope you enjoy.
Hi, today I am lucky enough to have with me Dan Bates, who is a mediator, who, if I understand correctly, you normally do court-appointed mediation, correct?
Yes, it's most of my work comes from the courts, but generally speaking, it's because the parties' attorneys have selected me and then the court approves it.
Okay, and welcome, by the way. It's nice to have
Thank
you
you.
here.
Nice to see you.
Thank you. So when I am working with clients, a lot of times I'm working with them from the beginning of their divorce when they're telling me they either want to keep their home or they're looking to see what they can purchase on a new home. And I'm trying to work with the attorneys to make sure the wording in the judgment of divorce is going to work for getting through the underwriting purpose. So whether the guidelines pertain to their income or how long they should receive support for, or if we're turning assets into income or whatnot, from the lending perspective, what needs to be done in a divorce settlement. And many times when I'm talking to people, they'll tell me that they have, mediation that was ordered from the court, and they don't really know what that means or they kind of know the intention is to get to settlement, but I don't think they understand the degree of what that means and what it looks like. And I always say to people, from my perspective, I can tell you, if you're going somewhere, you bring snacks, you bring a drink, you take Motrin before you go.
Good advice.
And I'm used to it being in two separate rooms, either by Zoom or in person. And my interpretation is not necessarily that one party is being told something that isn't true, but sometimes you have to be one-sided when you talk to the opposite person and then one-sided when you talk to the opposite person again, because your goal, from my understanding, is you got to get to this settlement agreement, and you're not necessarily acting as I have to make sure everybody wins everything that they want, but we have to come to a good conclusion to get to an end.
To many of your points, I'll address. Number one, I provide snacks and drinks for my guests because people they get hungry, they can get cranky. That goes for the lawyers and the parties. And so I try to provide a variety of refreshments for them so that they kind of can stay with it. With respect to the objective, yes, the objective is to bring the case to a settlement. I do it in separate rooms, generally, where spouse A is in one room with his or her attorney and spouse B is in another room with his or her attorney. I always have either my own office or another conference room to meet with the attorneys separately at times during the process. So it's a combination of a shuttle. I'll shuttle between the rooms. I'll meet with the attorneys. Every now and then, I'll get a case where the parties have been talking. They're not terribly acrimonious, and we can settle some issues by talking in one room. By way of example, there are times when I will meet with the parents if child custody and parenting time is at issue. And sometimes I'll meet with the parents without their lawyers and then ask the lawyers to tackle some of the financial issues while I'm meeting with the parents. So there's a lot of ways to do it, but to come to a settlement, people have to compromise. One of the adages that's popular among attorneys is that, well, if we make both parties equally unhappy, then we've done a great job. A bit of a glib way of saying it, but there's some truth to it. Some truth to it as well. Divorce is not a happy time, and when people come in, I have to measure not only what the positions are on the finances or on the parenting time, but also what their emotions are and what's in their heads, because people come in with different abilities to engage. Sometimes people need to ventilate, and we need to take some time and let them get it out. Let them express what's going on from their point of view. But I also always come back to the point of nobody gets their own way entirely in a mediation. There has to be some compromise. It's a rare case when capitulation is what occurs. It's rare.
Right.
And I have to recognize that even sometimes when a party takes a position that may not be legally tenable, perhaps from their point of view, it is.
Right.
And sometimes the law is counterintuitive to how people really think and feel as they're going through divorce.
Right. Because it doesn't always make common sense.
Right, exactly.
And what's the purpose or the thinking behind putting people in two different rooms?
It's to enable each party to be able to ask questions and express himself or herself without fear that the other side is going to hear them, judge them, belittle them in some cases. There are also cases in which there's been domestic abuse.
Mm,
And in those cases, I have to be very careful about putting people in the same room.
for sure.
Um, and cases are screened, by the way. I screen every case that comes in for domestic violence so that I know ahead of time whether there have been any issues.
Meaning you're
And
talking to people before you meet with them, or you're talking to the attorney?
I send out a questionnaire.
Okay.
So a questionnaire goes out. So when my assistant, Patrice, sends out the confirmation email, as far as this is when we're going to meet, this is what time we're going to meet, she also includes an attachment, which is a questionnaire that they're required to send to me, but to me only. So it doesn't go to the other side, doesn't go to the other attorney. It only goes to me. So this way I know before they come in if I have to be aware of that. And then oftentimes I will follow up with questions once the parties arrive.
Wow. And then do you get any prep from the attorneys of saying, hey, we're working on this issue and this is where I want you to concentrate, or we haven't done any negotiating at all and you're kind of starting from scratch?
Yes and yes.
Okay.
So I get the attorneys are required to provide me with a written summary before they come in, so that I understand, what are the facts from this party's point of view, from that party's point of view, what issues do we need to address? Has anything been settled yet? Um, Unfortunately, too many cases, there haven't been any negotiations or any discussions before they get to me. In again, too many cases, the discovery process has not been completed before they come in.
I was
So
going to ask you about that because I'm noticing that on my end when I talk to people and they say we're going to mediation. And I'm like, well, have you had any like rough settlement agreement in front of you? Like, and they're like, no, we don't even have the guy's financials yet, or
right,
and I'm
right.
always amazed that I was wondering if that was like a preference of yours, or because I hear that more than I don't hear it lately.
That seems to have increased in time, especially since the pandemic. During the pandemic, it was harder for lawyers to complete the discovery because they couldn't always get answers to their subpoenas to financial institutions, for
Okay.
example. It was also difficult to meet with people, and then everybody was getting used to doing what we're doing, which is Zooming, which
Right.
is kind of natural now. It's easier to settle cases when all of that's been done before they come to mediation. But if it's not done, then there are times when we take maybe we have to do more than one session. So perhaps the first session is spent kind of assigning homework to the parties and to the lawyers. This is what we need. Maybe there's a business that one of the parties owns, and we need to get it evaluated to determine what it's worth and what the business owner earns. So sometimes we set the table at the first session, and then in the second session, we can be more productive and work towards a settlement with knowledge. It's difficult to settle a case without the the knowledge that we need. So,
Right. And are you going through documents then of the parties and what they have? Or is that not part of, you're like, this is what we're doing, but the attorneys, it's their responsibility to verify that everything is true?
yes, now the mediation summaries are not sworn to. All right. They're basically, this is our position. With respect to documents, attorneys often attach documents to their summaries. So there could be court orders I need to know about, or there could be communications between the parties that I need to know about, or there could be account statements and they want me to look at, perhaps there's a claim of financial misfeasance. There are often claims that party A has been transferring money out of the marital estate in some form, so they will attach documents that show that.
Okay. And then you always hear you don't always hear, I always hear, we have to do this because this judge likes it this way or this judge expects that. And when they're in mediation, do you even note who the judge is? Does that matter as part of what you're trying to accomplish?
Yes, it does matter.
Okay.
Different judges have different preferences or trends. I won't say policies necessarily because
Right.
they have to be open-minded, and treat cases, individually. On the other hand, it's important to know the proclivities of different judges, and we try to tailor settlements oftentimes around what we believe that particular judge is likely to do if the case goes to trial. So this way, we can explain to the parties, certainly you reserve the right to go to trial if you don't like, what's being recommended during the mediation. On the other hand, this judge tends to do equal parenting time, for example. So
Right.
that might have a bearing on the outcome of that.
That's interesting. So it's like, I wonder if you're in mediation and obviously the goal is not to go to trial and you're getting close to settling, if you could say, well, we kind of made this decision based on if we were going to go to trial, but we prefer to do this knowing that we're not going to go to trial.
That's the case. And what I do what we do in most cases is we make an audio recording of what our settlement terms are. And in those cases, I will question the parties to make sure they understand the settlement, to make sure that there's been full disclosure of the financial information. I have to make sure they're not under the influence of drugs or alcohol, and I have to make sure neither party feels that he or she is being coerced or forced into it. So I also ask the question, do you understand that if you go to trial, the outcome could be different than what you've agreed to? So even though on the one hand, we're trying to, and with the attorney's help, we try to guide them into a realm of settlement that might be close to what we believe the judge will do. We can't say for certain ever what a
Right.
judge is going to do. So I have to ask the question, do you understand you could go to trial? You could have a more favorable outcome, or you could have a less favorable outcome.
And if
So,
they both sign the settlement agreement and then a judgment gets prepared and signed, most likely no one's going to trial, right?
correct, correct.
Okay.
Yes, and that's the whole point is generally speaking, people are going to spend way too much money going to trial on attorney fees and expert fees. And it's also the emotional and the physical toll that trial takes on people. They don't get done in one day. And generally speaking, trials are strung out over, could be a few months, it could be several months. And in
Hmm.
the meantime, especially with people with kids,
Right, and you
it,
have no
it
control. It's the most
right,
terrible thing I think that anyone could go through because you're used to being in such control of your own family.
right,
And now, because you're having marital issues, you've opened up everything, right? Everything that you work for, your savings, your employment, your children, all up to somebody else to make a decision of what they think is best.
correct.
Scary. It's very, very scary. I feel like sometimes by the time people get to the end, even without trial, they're just exhausted and just want it done and are willing to negotiate more than they would have been willing to negotiate at the beginning just because they need to move
Mhm.
forward.
That's true. That's true. People get worn out. And they at some point realize it's not worth the fight anymore.
Right.
Let's get it done. People often also lose sight of the big picture when they're going through a divorce, and they're so tied to the moment that they lose sight of, well, this may look different a year from now, or 2 years from now, or 5 years from now.
Right. It's very true. Do you have any good advice for anyone who's going to start the mediation process to help them mentally prepare better or?
Um, yes, they have to be prepared to listen as well as talk, and they have to be prepared to listen with an open mind and realize that there's not just one side to anything, and that I'm there to guide them, that their attorneys are there to guide them. They're paying their attorneys a lot of money to be advised, and more often than not, they should listen to the advice that they're getting.
Right.
And nobody in the process is going to try to steer them into something that isn't objectively fair and equitable.
That's good. That's good to know. Yeah, it's such a crazy, and my only experience is my own divorce going to mediation, which I thought was tough. I did not know what to expect when I walked in that room. I did not feel prepared, and I don't know if that was on purpose or not. But I remember not being prepared and hearing things back and forth. Sometimes I felt were very one-sided just to get me to make a decision because you feel so overwhelmed sitting in this uncomfortable place. And then I remember,
Right.
sometimes my attorney and I just sat there quiet, like waiting to get information. Like there was nothing to work on, there was nothing
Right.
to do but check email, or I don't know. It was a very weird time.
It is. There's a lot of downtime during the process, and I try to get people to work on an issue while I'm in the other room so that they're not just sitting there idly. Um, it's also helpful, very helpful, when the attorneys sit down with their clients before the mediation and get them into that mode and not into trial mode. And unfortunately, what happens a lot is I get the written summary from the attorney. The best ones are, these are the facts. Here's our position, here's their position, and they don't get into some of the vitriol.
Right.
Okay, but when the attorneys do include the vitriol in their summaries, it makes it harder and it takes longer to settle a case because now a party is seeing the accusations from the other party just before the mediation starts,
Oh, so they see all
oftentimes.
that.
And all of a sudden they come in and they're upset.
Yeah, that doesn't help, right?
Yeah. So it's helpful when the lawyers let them know what it's going to look like, and when
So
they can.
the summaries of each attorney goes to the other person.
Yeah, it goes to me, and it's exchanged with the other attorney, and then it's up to the attorneys whether to show them to the parties or not. I mean, more often than not, the parties want to see them and the attorneys show them to the party. But sometimes if they contain too much acrimony being expressed, the attorneys will choose not to show it to
Yeah, and then
to
you
the
wonder why, right? Like, I'm not showing
right,
you this. Well, why aren't you showing me this? I have a
right,
right to see it. Yeah, and then I'm
exactly.
sure you have a whole bunch of different style of attorneys too. You have the ones who like it to be emotional and pick fights and arguments, and you have the ones that, just really want to take care of business quickly.
Right. It's for the process to be the most successful, I have to be able to work with the lawyers who have to be able to work with the parties, and the lawyers have to be able to work together as well in order to reach a successful settlement. We get them settled anyway, even if the attorneys aren't working together. And I've, sometimes have to deal with attorneys who aren't getting along.
Right, I think you have to mediate the attorneys sometimes.
Yes, that's right.
And how long would you say a typical mediation session is?
Usually we set them for half a day, which means 4 hours.
Okay.
So it could be 9 to 1 and then, or 2 to 6. Sometimes the attorneys let me know ahead of time, we need the whole day for this one. So we'll set aside an entire day for it. Some cases settle in half a day, some settle in a full day, some need 3 and 4 sessions too. It depends on the complexity of the case and the mindsets of the parties
Right.
too.
Yeah, I would think the mindset has to be a really big part.
Right.
Well, I think you are very helpful, even to me. Is there anything that I'm leaving out that you think is an important thing for people to know?
Oh, I'm sure you and I could talk about this for hours.
Right.
Um, so perhaps I could get, we could talk again, and
That'd be
maybe there's
wonderful.
another topic we could pursue within the same
That would.
context of alternative dispute resolution. But no, I mean, for this session, no. I mean, I think you've
Okay.
asked great questions.
All right. Wonderful. Tell me, do you ever have people get a hold of you directly, or people should only find you through their attorney?
Every now and then, parties will contact me directly. Occasionally, I do pre-litigation, or what we call pre-filing mediation, where the parties contact me. Sometimes it's with their attorney's urging, and sometimes it's they've been referred by a friend or something, and they want to try to mediate the case before they file and hire lawyers. That's rare, but I get a few every year like that.
Wonderful. So tell me how they can get a hold of you.
Well, they can email me or they can call me. I'm online.
Okay.
Do you want my number and email?
I would love it.
Okay. Phone number is 248-792-6453. Email is dan@danbateslaw.com.
Easy enough. Well, I
Easy.
thank you so much for your time. This was great. I know it took me a long time to schedule time to talk to you. So I really appreciate you doing this. Thank you.
Well, you're welcome, and I thank you for giving me the opportunity.
For sure.
Okay.
I hope you enjoyed the podcast. I'm Carri Goldring, and if you ever have any questions regarding mortgage, feel free to give me a call or send me a text message, 248-420-4524. Hope you enjoy the rest of your day.